Hello and welcome to Law 2022 Online, Commercial Property Autumn Shape the Debate, hosted by me, Mike Georgiou from Move Reports. In this live session, you can put your questions to our experts, Richard Snape and Mark Shelton, and interact as the information is being delivered. Today's live Q&A is due to last 1 hour and will cover your pre-submitted and live questions. To the right-hand side, there is a chat function. All questions are submitted in private, so please ask away. If you are watching a replay and live chat function, the live chat function is disabled, but you may contact the solicitors group for further information. A recording of today's live session will be available on the website within the next few days. So on to introductions. Like I said, I'm Mike Georgiou. I have been in the property information and tech side of the business for over 22 years, originally on a scooter all over London from council to council conducting searches. Now I am more office bound with two roles as the Southern Director of Move Reports UK, directly looking after clients in London and the South. I am also the Managing Director of Navro Compliance Limited, bringing simple to use tools such as the LC5 Lender Check product and ART, an automated report on title, to the market that has been said to change the way people work. On to Richard. Richard has been the head of professional support at David Jones Board since 2002. He speaks at numerous courses for law societies all over the country, various public courses, in-house seminars within solicitors' firms, and has also talked extensively to local authorities and central government bodies. His areas of specialism include both commercial and residential property, in particular in relation to local government law, conveyancing issues, development land, commercial property, and encumbrances in relation to land. As part of Law 2022 Online, Richard Snape's sessions include commercial lease repairing covenants, service charges and dilapidations to 2022, alienation, alteration and user covenants, the problems and solutions. On to Mark. Mark has worked in major commercial law firms for 29 years. As a property litigator, he has acted for a range of clients from FTSE 100 investment companies and major corporate occupiers through to small businesses and individuals. He is an expert in commercial property management law and as well as advising on the structuring and documentation of transactions, Mark has conducted a wide range of commercial property disputes, acting both for landlords and for tenants. Mark is now a non-practicing solicitor and works as a commercial property management law trainer, putting his expertise and experience to good use in training both lawyers and surveyors. As part of Law 2022 Online, Commercial Property, Mark's sessions include security for rent, guarantees, deposits and other options, vacant property, property guardians and rental auctions. So to commence the session, we will start addressing some of the pre-submitted questions we have been receiving from you. So the first question is, where a property is left empty and tenants leave handing keys back on the assumption he has surrendered the lease and damages occurs by people breaking in and running the water upstairs, which goes unnoticed for over a month, can the landlord claim on the insurance policy or sue the tenant? Over to you guys.
Okay, thank you. I think that's one for me in the first instance, at any rate. So I think, the first question there is, is the tenant right to assume that the lease has been surrendered? And the answer is probably not, unless the landlord's been careless enough to have done anything to suggest that they've taken possession back. Therefore, the situation is as it would be if the tenant were in occupation and the damage occurred. So I think, the question is, can the landlord claim on the insurance policy or sue the tenant? And the answer is those two aren't mutually exclusive, really. I mean, there's no reason why the landlord shouldn't be able to claim on the insurance policy, assuming that the risk will be covered by the terms of the policy. If the landlord didn't sue the tenant, then the insurance policy would have a claim against the tenant. They'd be subrogated to the landlord's claim against the tenant. So one way or another, it's a liability which should come back to the tenant. I mean, I suppose the other question to ask there is whether or not the property has been vacant for long enough to engage the conditions in the insurance policy about notifying the insurers that it's vacant. And probably one of the conditions that would be included in the policy is draining down the water systems, so there's no danger of water leaks or anything of that sort. And if those conditions have been engaged and they've not been complied with, well, then it may not be on cover, in which case the landlord would be left to their remedies against the tenant. But I hope that's a sort of clarification of the issues there. Anything to add, Richard, on that one?
Yeah, I don't think handing the keys, like you said, unless the landlord's done something unequivocal as a consequence, amounts to a surrender. Is that case? I don't know, quite an old case, Stanningford and Bruce, which basically said that you're not surrendered the lease, you're still the tenant. And I suppose the good news for the landlords, I think, not only will the insurance, if it's been vacant for a sufficiently long time, require the landlord to perform various acts, it'll also put your premiums up massively as well. It's quite a topical little area. Another problem, I think, good news for the landlords, I've actually seen lots of landlords who, of late, with the market being what it is, not re-entering the premises, peaceably re-entering, which you can do as long as you're absolutely certain there's no one opposed to your occupation, because they don't want full business rates liability 3 months later on an empty property. And what they should do is, that's why they include Jarvis and Harris clauses in the lease. We've got to reserve the right to enter. You're still the tenant, you still pay the business rates and the likes, but we can enter and make sure the water is switched off and the likes, and shored up, and vandals don't get in. Also, a lot of concern about squatters, because it's illegal to squat in residential properties nowadays, but not commercial. They love commercial empty properties.
Yeah, I think that's it's a good point about the Jarvis and Harris clauses and about not doing anything which amounts to taking possession back. I mean, the cases actually give landlords quite a lot of leeway, but I think the safe approach is, if you're going to go into the property, then it should be in accordance with some express right in the lease, like the Jarvis and Harris right, and ideally not otherwise. So I think that deals with that one.
Okay. Next questions, I think, directed to you, Richard. I am going through a lease renewal. Can I ask for a change to the service charge provisions and make service charge subject to a reasonable test?
I couldn't advise on real life situations, so we'll make it hypothetical. I'm presuming it's a 54 Act renewal, and I'm presuming the reason you might want to change, if you're acting for the tenant, service charge provisions, is because of some of the cases that I mentioned from late 2020, early 21, this Sarah and Hussein and Black's Outdoor Leisure, and Criterion Buildings and McKinsey's management consultants, which basically said that, unlike residential service charges, there's no sort of automatic reasonableness test. There's no statutory control like there is in residential service charges. And if the landlord said that the certificate is conclusive, in the absence of manifest error or fraud or mathematical error, you have to pay. So I think it's not a bad idea, if you're a tenant from now on, to have some sort of reasonableness test. I think you should have been doing it some time ago. Or to make service charge have caps on it, or depend on floor area and the likes, to a bit more certainty. If it's a new lease, then it depends on who needs who the most in the negotiating stance. If it's a 54-out renewal, the starting point is Section 35. They're actually supposed to have regard to the terms of the current tenancy. May in City of London Real Property Company was actually about service charges, amongst other things. Said that the person wishing to show a change in terms, the burden is upon them. And it's quite a strong burden. It's got to be just and equitable between the parties and likes. So the starting point is probably no, unless you can persuade the judges otherwise. There's quite a few instances of county court judges being persuaded otherwise. I don't know if you've got anything to add to that.
I suppose just a couple of things. One is going back to the case of Finchbourne and Rodriguez back in 1979. So I mean, the courts will generally imply a reasonableness limitation on service charges anyway.
That was residential.
It was residential, but I think I think it's a generally held consensus that would probably apply to commercial as well. So I wouldn't be too hung up about whether the lease actually says reasonable or not. The Sarah and Hussein case, that's the other one which we mentioned. I think that's a really tricky one, and of course it's to do with whether the landlord's certificate is conclusive as to service charge. And the only kind of solution that I've got to that, which is a very litigator's solution, and nobody will want to do it because it involves spending money. But if one can prevent the landlord issuing their certificate, is the only way really you get the ability to challenge the service charge in that case. And I suppose the way you would do that is be in communication with the landlord and work out what they're doing and how much it's likely to cost. Ask the court, if necessary, for a declaration as to whether what they're doing is reasonable, and on the strength of that application for a declaration, get an injunction to prevent them issuing the certificate until you've had it determined, which is a horrible sort of heavy-handed, expensive way of dealing with things. But I think it's the only way you could actually guard against the implications of that case. I mean, it is going to be a sort of rather expensive way of doing things, but I mean, the McKinsey case was 2.2 million, over £2 million worth of service charge arrears, and it's not the norm, plus interest. So it might be the case in those sort of situations. I think the other thing in relation to service charges used on this tests and wanting caps, and this gets to be very, very complicated, is what might be around the corner in relation to service charge liability. Because before too long, landlords won't be able to replace like for like the heating systems and the lighting systems and the air conditioning systems because of energy efficiency. You don't want to pass the buck straight to the tenants. I think there's huge sort of issues there as well. Yeah.
Okay. Next question's for you, Mark. Why do the courts take the view that the covenant strength of a former tenant can't be taken into account when considering a request for consent to an assignment?
Okay, so I hope this is not trespassing too much on your subject matter, Richard. But anyway, I mean, this is obviously, if a landlord's going to object to an assignment, then one ground or one area where they're on absolutely safe ground is if they've got a legitimate concern about the covenant strength of the assignee, and where the landlord's able to have recourse against a former tenant, which of course if it's an old lease pre-1996, they'll be able to under the old privity of contract regime, but more commonly if it's a post-1995 lease, the former tenant's given an AGA, an authorised guarantee agreement, you can go back to them on the basis of an AGA. And if the former tenant is some company of enormous financial standing, then the obvious thing that an assignee is going to say, or the company is going to say when they're trying to assign to this, to somebody else, is, well, you don't have to worry too much about the financial strength of the assignee because you can always come back to us and we've got all the money in the world, I mean, the courts have taken the view that the landlord's entitled to have somebody who's in the property who's able to be a responsible tenant and pay the rent and perform all the other covenants in the lease and repairing the property and so forth. And it's much better having that than having the ability to go and sue somebody else who doesn't actually have an interest in the property. So that is the sort of rationale for it. I mean, I think the only thing I would say is that the court's views on what's reasonable do change, and they do change with circumstances. I mean, you can go back 50 years or more, and you find court cases where the courts have said there's no, it's no basis for refusing consent to an assignment. That you have a concern about the covenant strength about this insignificant subsidiary company, because it's got a great big parent company, and of course, just as a matter of commercial morality, the parent company won't allow its subsidiary to default on its obligations and go into insolvency. Whether that's a realistic view of modern day commercial morality is a different matter. Equally, I suppose, with the trend to shorter leases, if a lease is held by a very substantial company, and if with 2 years left or whatever it is, they want to assign somebody who is of less substance, I suppose a court might well take the view, well, actually, you do have sufficient security on the basis of the strength of the assigning tenant. I mean, there's no indication the courts are moving in that direction. It's just speculation, but it's entirely possible because circumstances do change and views as to what's reasonable change. However, for the time being, where we are with the case law is the landlord is entitled to have a tenant who is in occupation, who is a responsible tenant and can perform all the obligations. And that's why you can't have any reference to the fact that the previous tenant may have been Microsoft and they've got all the money in the world. So that's the rationale for that.
Yeah, I agree with that. Yeah, I suppose the other thing perhaps to mention is it's not just about the covenant strength issue. Is things do change, like you said, over time. And remember that Ashworth Fraser Gloucester City Council case about the cattle market in Gloucester 20 odd years ago now. That makes me feel old. House of Lords case that said there's not much scope for precedence in these areas. Cases often depend on their own individual facts. But I do agree with Mark, yeah.
Okay. We've had a question from the audience, so I'll read this. Given the current interest rates, how high can a landlord with a strong bargaining position go with the contract rate before it is considered a penalty clause?
Good. Who wants to? Do you want to answer?
Well, so where the courts have got on penalty clauses is that for a clause to be struck down as being a penalty, number one, it has to be a secondary obligation, which this would qualify for. Because primary obligation is pay the rent. Secondary obligation is if you haven't paid the rent, you've got to pay interest. So it's a secondary obligation. But then the next step would have to be that the penalty is out of all proportion to the default. Having said that, I mean, none of that takes us very far, really. I mean, it's a question about how much interest would be completely disproportionate, it has to be a question of market consensus, really, I suppose. My feeling would be that once you start getting to something like 4% above base, it's beginning to be fairly penal, and I begin to think, well, is that a little bit on the high side, and maybe 2% above base or something of that sort might be more reasonable. But that's just my view, and Richard, do you have any different sort of thought about that?
Yeah, I mean, I've not seen much discussion of it. I've not seen much discussion of people tended to forget and assume that interest rates will be low forevermore, so there's not being too much about it. Like you say, they had those Supreme Court cases from a few years back about wheel clamping and the likes, which said that these things are going to be secondary. I think if that's what the lease says, I think it's not so much what base rate's going to be. It's what the plus part, if you like, is going to be, like you said, if it's base rate plus 4 and base rate is 10%, I can't see, that's probably unreasonable. But if it's base rate plus 2, and base rate, and suddenly it becomes 12%, then it's, I can't see there's anything wrong with that. That's what you agreed. And if you agree with that, I think we'll probably have a bit on it in the future.
Yeah.
And I think as well, you sort of a bit on the side on it, where you see rent reviews based on RPI, we'll have a lot on it in the future as well.
Yeah. Well, it's a funny sort of consideration, isn't it? I mean, I think I agree. Certainly, it's the plus element, which is going to be where the interest, whether no pun intended, where the discussion centres. But if we say base plus 2 is probably reasonable, well, base plus 2 on top of 10%. Looks not unreasonable, but if interest rates are at 0.5% and it's plus 2, well then it's a 400% increase on the base rate. So do you start kind of scaling down what you regard as a reasonable plus element in those circumstances? Don't know. Yeah.
Okay. I think there's a lot pending in the world. Rising interest rates that we'd more or less forgotten about. I find it amazing that a lot of mortgage companies in the world of residential long leases are still accepting RPI increases. And they won't be big for too long, and that will be the next batch of litigation for the residential people. That's a nice thought.
Moving on, a question for you, Richard. If a break clause requires material compliance with the terms of the lease, what shall I do in relation to dilapidations?
Well, I wouldn't have agreed that in the first place myself, but you do still see it in leases, and especially some of the older ones. There's been lots of cases on it, and they're quite vague actually. And I think I'm not sure if I mentioned it in the webinar, but there was a case. I remember Fitzroy House in the Financial Times. You remember that one? About 2006, Court of Appeal case that discussed it. I mean, this was best part of £600,000 per annum rental, and it was a big claim. Something like £3.5 million lost if you got it wrong, and they had to material comply with the terms of the lease. And the court basically, as I recollect, distinguished between reasonable compliance with the terms of the lease, which means something different, and material or substantial compliance, the other words you see. And if it's material compliance, it's sort of basically as a landlord losing money as a consequence of the tenant's breaches, which is not an easy, it's quite subjective really. It's not an easy thing to look at. Is the landlord going to have to keep the premises empty whilst they do it up? Is it going to have to keep the give longer than normal fitting out periods? But it's almost asking for trouble. I think a much better bet in the future. It's been happening for some time. If I was a tenant, I'd want a clean break. Of course I would. If I was a landlord, I'd want absolute compliance with I think the code for leasing business premises has got it right. The basic rent has to be paid, giving up occupation, and subsisting any subleases have come to an end. That's what I would agree nowadays. I say it's almost asking for trouble.
I think just going to slightly playing devil's advocate, I think the contrary view is, if you're going to give a tenant a valuable property, the right to get to bring the lease to an end ahead of time, then why shouldn't the landlord at least expect to get the property back in a condition where he can re-let it?
Yeah.
I don't think it's an unreasonable concern on the part of landlords. I think what is unreasonable is the way in which the courts have approached the issue of compliance with repairing obligations, which is ludicrously strict. But I think because of that, I think it's right. You're mad if you're a tenant if you concede that kind of conditionality on your break option.
Do you remember that case in South Wales, Sir Harry and Henderson?
Yeah.
About 7 or 8 years ago. Dan's Bangers of Caerphilly, I always remember that, where they had to comply with the terms of the lease full stop before they can exercise the break, and they polished and they decorated all this kind of stuff on a big site. They left a couple of patches in the fences that got sheeting over it, and they couldn't break the lease as a consequence. They just should not have agreed that in the first place.
Yeah.
certainly not agreed that. I can take your point on material compliance.
Yeah.
And I used to do, I mean, it depends on who the tenants are and their covenant strength and likes as well. I mean, I used to do talks for Defence Estate. I'm not sure how much I can talk about it, actually. But you know, if you're a central government body, they usually, you know, you can usually sue them for antecedent breaches anyway, because they're worth suing eventually.
Sure.
I used to always be amazed at the number of people on the other side, where the Defence Estates were going to be the tenants who wanted the MOD to find guarantors. Well, if they go out of business, we're all going to be in quite serious trouble. So it depends on who the tenants are.
Yeah. Well, I suspect, I mean, no, there are so many leases with break clauses in these days, and everybody wants flexibility, and everybody's looking for clean breaks with no conditionality. And it's a lucky landlord who gets away with that sort of condition in their break clause these days. I mean, I just wonder whether at some point government is going to move towards some sort of regulation of content of short-term, low-value commercial leases, maybe adopting standard forms, maybe outlawing things like that kind of conditionality on break clauses. Don't hold your breath, but you know.
Yeah, if you said that to me 5 years ago, I'd know full stop. But nowadays, who knows? Quite honestly.
Yeah.
A lot of surveyors think the code for leasing business premises is some lawyers as well is legally binding. Can we try and jig people to that effect? Okay.
Yeah.
Okay, moving on. Next question's for you, Mark. You seem to be suggesting that it wasn't worth including wording to prevent the discharge of a guarantee by a variation of the lease. Is that right?
Not quite. I mean, I think you know, it is the one of two big exceptions to the rule in Home and Brunskill, which I discussed in that session, where variation in leases, unless the guarantor has consented to it, releases the guarantor. And one exception is the guarantor has consented to it. The other big exception is if there is effective anti-discharge wording in the guarantee covenant. You usually see wording to the effect that either the guarantor agrees in advance to any variation, or simply that no variation will discharge the guarantor, something of that sort. And I think when you look at the cases, and this is what I was saying in that session, that it is surprising how seldom that wording actually helps the landlord. And despite that wording, the courts are much more inclined to find that a guarantor has been discharged from their obligations. But it's not invariably the case, and there was a case actually just in August, which was Ocean Phil and Nuffield Health Wellbeing, and that was a case where part of the decision was the court saying, well, in any event, the guarantor is not discharged from their liability because there is this anti-discharge wording in the covenant. So it does work. Given appropriate wording, it's certainly something you'd want to have in your guarantee covenant. But I think as I said in that session, the key thing is to get guarantors' consent to any variation, and to be alive to things that don't look like variations but actually are, often terms in licenses to assign or licenses to alter, people entering into a stepped rent arrangement on a rent review, that sort of thing.
Yeah, I think you're right again, and sort of not always obvious whether something's a variation, and obviously the landlords don't consent to having their liability increased.
Yeah.
There was that B-gas case, wasn't there? B-gas and BHP 20 odd years ago about changing the rent review patterns. It was actually an assignment at least. You remember that one?
I don't remember that one actually, no.
They changed the rent review patterns. They had a market rent review. They assigned the lease, and the landlord and assignee got together and changed the patterns to a stepped upwards rent. And the court said that you're not liable for the increased liability. This was just before the market fell off a cliff in the early 90s. It must be 30 years ago you're just liable for, as a guarantor for what you're sort of the bare minimum.
Yeah.
The worst about variations and guarantor's liability is where the variation is so fundamental, it's a surrender and re-grant. And there's a few of those going on, adding to the term or adding to the duration, adding to the demise, sorry.
Yeah. But no, well, I think, as we both said, I mean, it's the disguised variation which is the problem, because if the file in front of you says Unit 19 deed of variation, then you start thinking, oh, surrender and re-grant, home and Brunskill, but not necessarily if it says rent review. So, yeah.
Mm. I mean, in that BGAS case, they went bust. It wasn't a very good idea to replace upward only market rent review with a stepped upwards rent just before the market fell off a cliff.
Right.
And there were about the only tenants in the country paying more higher rent each year in the early 90s. That's why they go bust.
Yeah. Yeah.
Okay. Next question's for you, Richard. If there is an absolute ban on structural alterations in the lease, can I persuade the landlord to waive this?
Well, you can always persuade the landlord to waive an absolute ban if they agree to do so. I mean, landlords tend to want things like absolute ban on structural alterations. I suppose the proviso, and it was a case in the notes I think I mentioned, it was actually a residential case from a couple of years back now. Duval. You remember that one, Mark? Duval? Dr. Duval, that is a cool name. And 11 to 13 Randolph Crescent.
Oh, yes. Yeah.
It was a Supreme Court case, and so it is residential, but there should be there's no sort of real difference. That they got an absolute ban on structural alterations, and there was also provision in the lease that at the behest of any other tenants of these, there's about 11 flats in these 3 large townhouses in Maida Vale in London that have been knocked into one. And the landlord had to take enforcement action for any at the behest of any of the tenants, against any other tenant who was in breach. And the landlord they had 2 flats in this premises, and they wanted to knock them into one, which requires structural alterations, and the landlord was prepared to do it, but the other tenants didn't want him to, and the landlord had to enforce the covenants, basically. And that's a Supreme Court case. So in the normal course of things, with if you're just a sort of single let and the likes, it just depends on what you decide between landlord and tenant, but you might have issues in sort of multi-lets and the likes.
Sure. And just the other thing to add, I mean, just going back to the previous question, it just brought to mind the case of Toplum Portfolio and Smith Holdings Limited. Yeah. That was 2012, I think it was, or thereabouts, 2014, and a case where the lease had an absolute ban on structural alterations. The tenant asked for consent to do structural alterations, and the landlord said, yeah, absolutely fine. So they entered into a license to alter. Fast forward 25 years, when the landlord then comes to call on the guarantee of Smith Holdings Limited, the WH Smith parent company, who said, well, hang on a minute, this so-called license to alter is actually a variation of the terms of the lease, because you've allowed the tenant to do something which would clearly have been a breach of covenant if it weren't for the document, and we're released from our obligations, and court agreed. So that's a good example of a disguised variation.
It's a good example of nothing. No one's spotting the problem until 25 years later. They wanted to enforce. Yeah, it was just there waiting to be a problem in the future.
Yeah.
It's quite an amazing case. This case, when you say it was sort of 2012, I'm sure it was, but when you mention the dates of these cases, it just makes me feel so very old.
I know. Well, you and me both.
Seems like the 1925 property legislation was only yesterday.
Next question's for you, Mark.
Yeah.
Could a parent company guarantee be preserved on an assignment if the lease was granted to the occupier and the parent as joint tenants?
Okay, so that is something that people sometimes suggest as a means of getting around this issue of trying to keep a parent company guarantor on the hook when a lease is assigned. And it's sort of ingenious. I think there are two issues with it. The one practical issue is there are going to be things which joint tenants have to do together, like serving notices or responding to notices or applying for lease renewals and so forth. If this structure actually works, and what began as PLC and a subsidiary company, so subsidiary company taking the lease, PLC as the guarantor, and there is then an assignment, so the lease becomes vested then in PLC and some other company, which is a total stranger to the parent company. And they are joint tenants, and if they can't agree on formal matters like that, which they both have to do together, well, then you've got a problem. So that's number one problem. The other problem, which is a really sort of rarefied one, actually, and this is the kind of thing you come across in a totally different context. If you've got, professional partnerships, whole leases, and the lease is granted to, A, B, C, and D. D is going to retire. And so the partners agree that the lease will from now on be vested in A, B, C, and H, taking time off from line of duty, presumably. But so you got the lease should be assigned then from A, B, C, and D to A, B, C, and H. And this is one of the kind of things thrown up by these cases on the release of guarantors. I mean, it's not actually discussed in any of the cases, but it's something that commentators have said. Is that if you have an assignment from A, B, C, and D to A, B, C, and H, well, A, B, and C are never actually released from their covenants, as they should be on an assignment. And therefore, the arrangement should fall foul of the anti-avoidance provisions of the Landlord and Tenant Covenants Act 1995, and it wouldn't work. So that, I think, is I say, the slightly rarefied technical issue behind it. But it's not something which is done, to my knowledge, for those sorts of reasons. I don't know if there's anything to add there, Richard.
Not particularly on that. I think, couldn't really. No, that's. I agree entirely.
Okay.
Okay. Moving on, the next question's for you, Richard. How, as a landlord, can I argue against the change of use from commercial to residential when this is not banned by the lease?
This is, amongst other things, although not exactly to the point, it's sequent nominees, isn't it? I never know. Is it Hortford or Houtford, Mark?
I'd pronounce it Hoford myself.
H-A-U-T-F.
There's a third,
Okay. We won't
third
have
choice.
Seeing it's a Supreme Court case and it's comparatively recent, it's December 2019, majority decision. I was amazed that it reversed the first instance decision, but it's got the Court of Appeal decision. But it's got sort of background to it. I mean, it did mention case International Drilling Fluids in Louisville from 1986, Court of Appeal case, which sort of talked about what's reasonable to refuse consent, primarily to alienation, but potentially for user and alteration covenants as well. And amongst other things, they said that you could refuse consent even though it's not a breach in the terms of the lease. And there's another case that's mentioned in my notes called Moss Cross CSC at the end of the 90s, which said pretty much the same thing. You could refuse consent to an assignment, and they were talking about user, on the grounds of the user by the tenants, even though it wasn't a breach of the terms of the lease, it didn't fit within your estate management plan. This was the Metro Centre was Moss Cross and CSC in the Northeast, Gateshead. And the landlord sort of allocated that part of this huge shopping centre for men's clothing. And Moss Cross wanted to assign to somebody who was going to be selling computer games and successfully refused consent to the assignment. Sequent nominees, if you take it at face value, you got to it's a Supreme Court case. It was actually about, I say it wasn't exactly to the point, it was converting residential units in a block in London, Soho. It's a 6th-floor block. The tenant occupied the basement and ground floor, and there were a couple of commercial units, a couple of residential units. And the landlord the tenant wanted to convert the 4 upper units were sublet, and they wanted to convert them into residential. There was no breach of the user covenants in the lease, but there was provision that if the tenants wanted to make a planning application, they had to get the landlord's consent not to be unreasonably withheld. And the landlord refused consent because he didn't want the prospect of the tenants arguing this property is now a house and we can franchise it on the cheap, even though there's 70 years left on lease. And eventually the Supreme Court agreed with the landlord. You can take into account your own demands and needs, even if, unless the tenant's needs far outweigh yours. So that's the possibility. You can refuse on other grounds, basically. It doesn't have to be a breach of the terms of the lease.
What always strikes me as kind of storing up problems about the approach that the Supreme Court took in that it is in deciding whether the landlord's not supposed to use an application for consent to try to obtain a collateral advantage, something which isn't contemplated by the terms of the lease. And the approach the court always taken in these kind of issues is to look at what the covenant is there for. What is the point of the covenant against assignment or whatever it is, and is the landlord trying to achieve some advantage which is above and beyond the protection which he's supposed to get from that covenant? And the approach they took in the Sequent case was to say, well, you don't have to go into a sort of close interpretation of the terms of the covenant to discover what the purpose of the covenant was. It's a kind of it's a kind of in the round decision on all the circumstances as they exist at the time of the request. And you don't have to go back in time and see what the parties were thinking at the time they entered into the lease. And I think it's quite hard on the basis of that to now identify what is or is not a collateral advantage, really. But that's the kind of slight concern that I have about it.
The problem I have, and you've got to accept it, it is a Supreme Court decision, is I forget which dissenting, one of the dissenting judgments, one was wholly dissenting and one was part, but he pointed out the obvious fact that it was a 100-year lease with 70 years left on it. It was a lease from the 1980s, I think. And they paid a premium, a peppercorn rent. And the dissenting judgment pointed out that, to get a relaxed user covenant you can use for both commercial and residential use meant that you probably paid a greater premium, or definitely paid a greater premium or a higher rental. And it didn't really take into account that fact. It doesn't really take into account commercial reality. But it's a dangerous one for tenants. You can just spring, you don't have to have highly restrictive user covenants in the lease if you can do the same in a roundabout way. Yeah. I suppose the other thing to mention, and I did briefly mention this in the course, is that in England, to a lesser extent in Wales, the use classes have been changing this last couple of years or more now. So suddenly you find situations where you don't need planning permission for a change of use anymore. And so you can go ahead, as a tenant, and landlords haven't really always got to grips with that, the change of the use class.
No, that's quite true. Yeah.
So it's a tricky one. I think it's one for valuers as well, quite honestly.
Okay. Next question's to you, Mark. Should guarantors have separate representation when the lease is granted?
In an ideal world, yes. I think in the real world it doesn't happen very often, or at least not formally, and it's potentially problematic. I mean, I think there's a number of things that if you were a separately represented guarantor, things that your solicitors might be raising with the landlord in terms of what the guarantee says. I mean, might you have, for example, a term that the landlord is required to keep the guarantor informed as to whether there's any tenant default, so there's some kind of warning of what's coming down the line, for example. That would be useful. Might you have provision to substitute a guarantor? If the guarantor wants out and they can find some other suitable covenant to put up instead, that might be the kind of thing you'd look for. If there's a difference between the position of a guarantor and the position of a former tenant. In that if a former tenant, if there's going to be a claim against a former tenant, the landlord has to serve on them a notice under Section 17 of the Landlord and Tenant Covenants Act. You don't have to do that on a current tenant's guarantor. And service of the Section 17 notice gives rise to the ability to call for an overriding lease. So at least you get possession back and you get to sort of take control of the process. And there's no such right for current tenant's guarantor. So again, you might try to negotiate a call option, for example, if the guarantee is called upon. So all kinds of things you might ask for if separately represented. Usually, I think, insofar as a guarantor company thinks about it, they might think, well, because our subsidiary is represented, then our interests are being looked after, that is probably not the case when you look at the retainer, and it's the subsidiary company which is retaining the services of the solicitors, and they're representing the subsidiary company and not the parent company guarantor. Although very often, there will be amendments suggested to the form of the guarantee obligation. And I think solicitors have to think carefully about, are they thereby taking on responsibility for acting for the guarantor as well, without proper engagement procedures, and maybe not thinking too hard about conflict of interest in those sort of circumstances. I think it's a difficult one, and sadly, nobody wants to be paying solicitors lots of money, so people don't tend to have separate representation for guarantors. But a guarantee is particularly with a longer lease, it's a serious commitment, and I think guarantors ought to be separately represented, really, but they often aren't.
I think it's like you say, they won't want to pay for it.
Yeah,
I think what you do, and I mean, it's not again exactly to the point, because it's not really leasehold, but it's all those undue influence cases involving family members putting houses up as security for business debt, and the Royal Bank of Scotland, Etheridge number 2. 2001, that one. But the House of Lords case, which basically said that there's a manifest disadvantage. There might be sort of potentials for undue influence, and the vast majority of occasions you tell them to be independently, separately represented, but you don't insist on it save in exceptional circumstances. In the vast majority of occasions, they won't pay for it. And if you start going too far down the line, as the tenants, solicitor giving the advice, you're in danger of, like you mentioned, having, conflicts of interest on your hands and legs. Sure. Be separate.
Sure.
Okay.
And actually, it was actually just before leaving that, I mean, it is something that I mentioned in my session on this. A case that, didn't you remember it? Trustees of, was it Beardsley, Theobald Pension Scheme and Yardley? That was a case of a guarantor being set aside for undue influence.
Yeah.
That rather peculiar circumstance where poor old Mr. Yardley was tricked into signing the guarantee at the bottom of a lease. That here, sign this. You're just witnessing somebody else's signature, and of course he wasn't. But hopefully, that's a fairly unusual set of circumstances.
Yeah, that's true. I mean, there's the exceptional circumstances are you probably never come across in your whole career. Quite frankly, you might come across it if you're very unlucky once.
Yeah.
Twice would be unfortunate.
Yeah.
Okay, moving on. Next question's for you, Richard. Can you explain the Competition Act 1998?
Well, that should take us to the end.
Yeah. short from me, but
well, there's 2 or 3 liner in my notes at the end, I remember. It hasn't really taken up. Because 1998 Competition Act is actually European legislation. It didn't. Land agreements were exempted until I think it was 2011. And what it basically says that you can't have clauses which prevent, distort, or restrict competition unless the consumer benefits, the benefits to the consumer outweigh the detriment. And there's so many issues in relation to it. How do you decide what the sort of market is for one? Basically how far would people go to get that product? Is that high street an individual market? Is the town centre an individual market, or 2 neighbouring towns individual markets? And also, what kind of percentage distorts competition? I remember the OFT, the Office of Fair Trading, as they were, CMA nowadays, Competition and Markets Authorities taken over, said you're looking at something like 10 to 15 of the market. It's very specialist stuff. I remember back in 2010-11 when it was coming in, before it came in, quite a few people, I talked to local authorities quite a lot, and quite a few local authorities were going through all their precedents and all their leases. Could the user covenants be preventing, restricting, distorting competition and changing things left, right and centre? We've had one reported case on it, and that was actually on a lease renewal. There's a case called Martin Retail Group and Crawley Borough Council, not well reported. And they sprang it. I'd say it wasn't primarily about the Competition Act and user covenants being breached. It was a 54 Act renewal, and quite frankly, the local authority was sort of nonplussed by the whole thing and not prepared for the argument. But it was it's probably a good illustration where you have to be a little bit on your guard. It was in Crawley. There's a row of 11 shops, and they had user covenants. This particular Martin Retail were McColl's. You probably know them as. And it was a news agent. So always remember, it could be the premises was had covenants to. They could only use the premises for news agents, tobacconist, and toy shop. So presumably the children of Crawley have got all their needs in one place. But they, and then these 11 shops, there's a kind of mix you see in the high street. There was one hairdresser, there was a general convenience store, there was an accountant, there was a laundrette, and that kind of fish and chip shop, everything you need in life. And they wanted to change from news agents to a general convenience store. They wanted to sell food and alcohol and likes. And they succeeded, on the 54 Act renewal. So it's not been perhaps as significant as people imagine, and it's not a bad idea on a 54 Act renewal if you want to change your user covenants. But that's a nutshell version, very much a nutshell version.
I mean, I just say, that Crawley case. One of the things that struck me about it is, if you go to the Competition and Markets Authority guidance as to land agreements and the Competition Act, but it looks like the yellow pages. It's about that thick, and it's all, there's no pictures, and it's more or less incomprehensible. But I mean, what happened in the case is, because the evidence was completely unsatisfactory, the county court judge did what county court judges do and said, well, I'm going to use my common sense. Here you've got a parade of 11 shops serving a local housing estate. That defines the market. Yeah. And, therefore, even a small amount of restriction will have a significant effect on competition in this small market. And I think that's the sort of, that sort of demystifies things a little bit and shows you can actually do something with this rather complicated sort of set of ideas.
I think also in that case, the landlords were just completely nonplussed by the argument. It wasn't argued particularly well.
Oh, shocking. Yeah,
polite. But yeah, it is an interesting one though. So but whether it takes off in the future is another matter.
Well, I seem to recall that the tenant had conceded that as a result of widening out the use clause, their rent would go up by the princely sum of £150 a year. Yeah. So there's not a lot of money involved in that case, And had I been the local authority, it wouldn't even have got to the competition stage. I'd have said, look, first point, OMA and City of London Real Property Company, you've got to justify departure from the terms of the old lease. And then, if you think that the proposed restriction on your user is anti-competitive, prove it. You can go and get a academic economist to produce a kind of 200-page report at the expense of about £20,000, and you prove it. And they would have dealt with it that way. But anyway. And
like you say, the CMA guidance is like a book. Yeah. I suspect it's one of those things that, if truthfully, it's a bit like Finnegan's Wake. No one's really ever read it, but not even the people who wrote it. Yeah. But, yeah.
Okay, so moving on. Question for you, Mark. How come a landlord can market a vacant property while at the same time apparently not exercising possession and accepting a surrender?
Rather neatly, that takes us back to the same territory as the kind of life question, which we dealt with right at the beginning, actually, about landlords not accepting surrenders, and it is a bit odd on the face of it that you can actually, you can put up letting boards and you can show people around and you can get your letting particulars out. None of that amounts to taking possession back. But there's a couple of modern cases, RVB Investments and Bibby, and Punge and Padwick and Punge Lloyd was the other case as well. Cases where the part of the landlord's conduct, and I mentioned earlier on, the cases give landlords quite a lot of leeway in relation to what they can and can't do in these circumstances where tenants kind of hand back the keys and disappear. In both of those cases, landlord had got the property, chucked out all the tenants' waste, made them secure, cleaned everything up, put the property on the market, shown people around, and the court said, no, that's not an unequivocal acceptance of possession. If you go to the stage of actually discovering a new tenant and letting the property to them, then that is an unequivocal acceptance of possession from the former tenant. But you might, if you don't go to that point, if you're just marketing the property, the point of the exercise might be to find a prospective tenant, and you can then contact the former tenant and say, look, here's somebody who'd taken assignment of the lease from you. Should we work things out that way? So it's not unequivocal. You're not unequivocally saying the lease is going to come to an end and we're going to take possession back. But yeah, the courts are quite generous to tenants in this respect.
Yep, I agree entirely. I say it goes back to where we started off, which is a bit like Finnegan's Wake as well, actually. But I'm getting quite literary now. I think that's all I've got to say, really.
Okay.
Well, on that note, that's unfortunately that is all we have time for today. So, thank you for attending LAW2022 Online, Commercial Property Autumn Shape the Debate. Don't forget to join the solicitors group LAW2022 Online community on LinkedIn to continue the debate after the live session and to be included in exclusive offers for future events. As I mentioned at the beginning, a recording of today's live Q&A will be available on the website within the next few days. If you have purchased the online course, there is still time to watch the pre-recorded content. Your expiry date will be displayed next to the webinar. If you have not, then you can still buy the complete event, including a recording of this live session. To book, just go to www.thesolicitorsgroup.co.uk, where you will also find the online exhibition. The exhibition is open for anyone to visit, and if you have booked the entire event, you can claim your free 1-hour CPD webinar from the webinar learning catalogue, worth £35 plus VAT. Finally, the feedback form for this course is found in the related links section, and by completing and submitting this, you will receive your CPD certificate via email. So, to end, thank you once again and have a great day. Thank you, guys. Bye.
Thanks.
Okay.
Goodbye.
Goodbye.